in the matter of HMRC and Malde and another.
Mr Hayhurst.
My lords, Mr Way has kindly put on the bench an A3 printout of one of the documents in the supplementary bundle. It's not much more readable than the actual documents in the supplementary bundle. I'll very, very briefly be going to it a bit later on.
This is something to do with the chains, is it?
Is the ground three. If you were to permit me to go to 7 factual documents in the space of a few minutes, that will be one of them. I'll be very brief. But if I can continue then my submissions as to why the burden of proof being on the taxpayer with the question of, with respect to the question of liability was compatible with Article 6 and applying the test we saw at the end of the Eurowines case was reasonable and proportionate. I'm making 5 points as to why the burden being on the taxpayer is both reasonable and proportionate. The first of those points is consistency with 2 previous decisions of this court, Khan and Doorstep Dispensary. Yesterday I went through Khan and I now turn to Doorstep Dispensary. This was a case before this court where the Information Commissioner had levelled a penalty upon Doorstep Dispensary of initially around 275,000, but then reduced during the court process, I understand, to about £95,000 for breach of the GDPR obligations. The question arose in that case as to where the burden of proof fell in relation to the penalty. I stand to be corrected but by the court's better knowledge, but in some ways this is quite analogous to the penalty alone scenario we find ourselves in now, because it was a penalty in this case where in Doorstep Dispensary where the question of underlying liability was being determined. We have a hard copy on the bench, and at paragraph 31 the court stated that they found most helpful the previous Court of Appeal case of Khan for reciting it and then giving this evaluation at paragraph 39. In my view, however, the burden of proof lies on the appellant in the appeal against the imposition of a penalty under section 155 of the DPA. The commissioners must, before raising a penalty notice, be satisfied that one of the conditions specified in section 155 1A and B is met, and that it is appropriate to require the person to pay the penalty. Where, however, the recipient of a penalty notice appeals under section 163, it seems to me to be incumbent on him to persuade the FTT that the penalty should not stand. Khan-Worth Law Justice explained in Khan that the general principle is that where a statute gives a right of appeal against enforcement action taken by a public authority, the burden of establishing the grounds of appeal lies on the person appealing, and that the ordinary presumption is that it is for the appellant to prove his case. Far from suggesting this general principle is limited to challenges to the refusal of benefits as opposed to the imposition of penalties, Khan-Worth Law Justice explained that it applies to enforcement notices served in respect of breaches of planning control, and that he considered the approach to be the correct starting point in relation to an appeal against a civil penalty. As regards the latter, the burden was on customs to establish tax evasion and dishonesty, but that was because section 60, subsection 7 of the 1994 Act expressly so provided. Further, in the present context, as in Khan, it is the appellant who knows or ought to know the true facts. The Commissioner did not, of course, witness the documents coming into DDL's hands or crates, boxes or bags being placed in the yard of the property. She was working from what the MHRA found. DDL, however, should be aware of how it came to have the documentation and the circumstances in which at least some of it was put in the yard. The DDL should be in a position to explain the matters in the clearer, because Article 5.2 of the GDPR provides for a controller to be responsible for and be able to demonstrate compliance with paragraph 1. So we place reliance on that paragraph. We say that correctly interpreted and understood the previous Court of Appeal case of Khan, particularly in relation to the impact of paragraph 67, subsection 7. We further highlight the importance, and this will be my second point that I'll come on to in a moment, as to the burden being on the taxpayer or being on the person challenging the appeal, because they are in possession of the evidence.
Presumably you accept that paragraph 39 is part of the ratio of doorstep and therefore binding on this court?
Yes.
The principles set out in it?
Yes. And in particularly the analysis and interpretation of the impact of 67, which we say the Upper Tribunal in this case misunderstood, and I'll come to that in a second.
Does doorstep deal with Article 6, paragraph 2 of the CHR? The passage you've shown us just seems to be, I don't mean in disrespect by saying this, it's a classic analysis of domestic legislation, but is there any consideration of whether so interpreted the legislation is compatible with Article 62?
Not directly at paragraph 39, but it quoted Khan from paragraph 31 onwards, which of course did consider Article 6.2,
Yes.
and so was very mindful of that.
I must admit, I don't remember very well, but I don't remember there being an Article 6 challenge.
Can I also just, since we've got this passage in front of us, the principle in Khan, which is quoted in the middle of paragraph 39, that it's for the appellant to make their grounds of appeal. Should we understand all of this to be concerned with questions of fact? Because obviously in principle you can appeal on grounds which are not to do with facts, but is this learning all to do with where the burden of proof lies? Because burden of proof is really a concept relevant to questions of fact.
Yes.
Is that right?
Yes, and we see at the end of that paragraph, which is why I continue to the end, it was talking about
Yes,
questions of fact.
absolutely. I completely understand that, but I just wanted to be clear that when one says that the general principle is that where a statute gives a right to appeal against enforcement action taken by public law, the burden of establishing the grounds of appeal lies on the person appealing. We should understand that to be in relation to questions of fact.
Yes. And that comes to my second point that I'm going to make in a minute. And this is really is why we say one of our when I come to my second point in a minute of my 5, as to why it is very reasonable and proportionate, is because the citizen or the taxpayer is in possession of the evidence, and it would make it incredibly difficult, certainly in some cases, for HMRC or the government agency to be able to make out its case. And so I'll come to elaborate on that in a moment. But can I just finish off this this first of my 5 points by then returning to the Upper Tribunal's decision and its reference to Khan, and it may be the most helpful one is on page 105 and paragraph 111. If I read that paragraph through with comments. So core bundle, tab 6, page 105. Paragraph 111. The Upper Tribunal is very clear in its decision in Zaman. However, we do have some reservations about it. In particular, there is no reference in the decision to the potential application of Article 6.2 ECHR. I'll just pause there for one moment. I didn't make this point yesterday, but notwithstanding the fact that Zaman doesn't mention Article 6, my submission is it is consistent with it, because essentially it is giving effect to the principle of separation in Gisela. And so had it been mindful of that Article 6 guidance, that would have only supported, we say, its reasoning. I carry on. Nor is there reference to the leading cases on burden of proof in the cases of penalty assessments, such as King versus Walden, Khan and Eurowines. Well, pausing there, King versus Walden, for the reasons that I set out yesterday, is actually helpful to HMRC and consistent with our position. I'll come on to address Khan in a minute, and we're dealing with that now, and in due course I will address Eurowines. I continue. This is so notwithstanding that the practical effect of the decision of the Upper Tribunal in Zaman appears inconsistent with the guidance of Carnwath Lord Justice in Khan, albeit in a different statutory context, in that Carnwath Lord Justice accepted that some essential elements of the underlying tax liability, e.g. whether the threshold was exceeded, were part of the issue of evasion and for HMRC to prove. Well, it's that passage there where we submit the Upper Tribunal misunderstood Khan, because it was only saying, Khan was only saying in my submission that it is for HMRC to prove the matter of evasion or the threshold, because that question was subsumed within the intention to evade VAT, which section 67, by way of statute, put the burden on HMRC. Later on in Khan, as we saw yesterday, it's very clear that he says unless statute says otherwise, the burden should be on the taxpayer. So that, we say, is the nub of the Upper Tribunal's misstep with respect of its interpretation of Khan. And I would further make the submission that, of course, that this provision, section 60, is the very provision that was being dealt with in Giorgio, which is the one case where separation was not possible. And because of this confusion that we see here, and because of the aspect of the threshold being subsumed within the intention question, it further evidences my submission that it was difficult for a separation to take place in the case of Giorgio. And we have checked overnight, and that in the earlier regime in Giorgio, which was section 13 of the 1985 Act, there is the same provision as 67, which is that the burden is on HMRC to prove those matters of evasion. And just before I leave this point, I make the wider point that my learned friend's submissions on where the burden falls in the penalty regime are somewhat anchored in these dishonesty provisions of section 60, Giorgio, which was the earlier version of section 60, and they've also included in the bundle section 8 of the Finance Act in relation to excise matters, which is a similar provision. Well, all these matters have now been repealed, save for the transitional provisions as to when they now hold, but they're repeal matters relating to dishonesty where there's an infusion of liability with a mens rea dishonesty elements. That's very different from the regime that we're now dealing with. And so I would urge the court not to be distracted by that previous regime, which dealt with liability and culpability very differently. I now turn to the...
Just pausing there briefly. Under the previous regime, there were specific statutory provisions putting the burden on the revenue and as to certain aspects. But you accept that you still have the burden on such aspects, really, don't you?
On culpability aspects, yes. But my point is that whereas on that particular provision with respect of in relation to section 60, there was a melding, an interfusion of liability and evasion and dishonesty, which hence Giorgio found it very difficult to separate. But we're not in that sphere under the new 24 and 41 because there's a very clear dividing line between liability and mental element.
Can I just think around that for a moment? Suppose to establish dishonesty, you have to show what was going on in relation to the loads, say, and you accept you have the burden on dishonesty, does that mean you have an intermingling such that really the burden on dishonesty has to carry through to the question of liability?
No, well, no, for a few reasons, because in our case, we were dealing with different traders and different assessments, essentially. Sintra SA, for a certain period between 2004 and 2011, that was what the dishonesty director's liability associates relate to. We then moved into a new period where there was nothing of that sort from 2011 to 2014. It was the new penalty regime of Schedule 24. So it was very clearly set out. The facts differed, which we say is partly why we were unsuccessful, because there was an insertion of this buffer trader called Adrena. So it was two very different, and that's evidence, we say, by the nature of the decision, because it was dealt with separately. So we say it was a very separate, in the facts of our case, there isn't a crossover.
In which case, let me just go back to Khan for a moment, and I haven't got that in front of me, but Lord Justice Carnbeth says, well, when you're dealing with the Section 60, subsection 7 question, you have, if you're the revenue, at least to show you've got over the threshold or something like that. And you say, well, Section 67 has gone. But if you accept that you have the burden on dishonesty or whatever, does it really make a difference that Section 67 has gone?
There is no dishonesty in the new regime. There is no dishonesty. There's only culpability elements to be decided after liability has been determined.
In relation to the global period, is it right that HMRC did still plead a case of fraud up front?
In the background, because this goes back to the point.
I mean, you say in the background, but it was in the foreground, wasn't it?
Yes, I say in the background because it wasn't an element of the penalties or liability notices, and this goes back to the point I was making yesterday when I was relying upon the passages from Lord Justice Mustel and Brady to say that shouldn't impact upon what is the actual test.
I understand that. I just wanted to be clear as a matter of history, so to speak, that the revenue did in fact plead a case of fraud in relation to the global.
Yes, we were saying it was inward diversion fraud, it was smuggling. We didn't shy away from that because we were just essentially took the view we had to call a spade and say what it was.
And the tribunal didn't make any findings of fact on, is that right? On
they make, with respect to, not with respect to the Sintra Global Period, with respect to Sintra SA, they essentially found we made out our case. I mean, although I have to say the FTT didn't even go as far to sort of give a specific analysis with respect of dishonesty per se, but the clear inference or implication is that we had made out our case with respect to that. I'm grateful to Mr. Way. He indicates there possibly was an Article 6 point in doorstep at paragraph 162.
Was it?
Oh, in the Upper Tribunal.
I see.
In the Upper Tribunal. Can I then move to my second point as to why the burden being on taxpayer is reasonable and proportionate? And this is who holds the evidence and the workability of the system if the burden is on the HMRC or the government agency. I've already referred to, and I won't go there again, the cases that make this point about who's in possession of the evidence. Khan makes this point, Doorstep Dispensary makes this point, albeit an FTT decision, Omar Minerals made that same point in separation. I do just want to go to the House of Law's decision in Sheldrake, which makes the point, but also clearly sets out that test we saw yesterday in Eurowines in terms of reasonableness and proportionality. Sheldrake can be found in volume 1, tab 19 of the authorities manual. The head note is at 259. This was a joint matter coming before the House of Lords in relation to the compatibility with Article 6 of two reverse burdens. One, in relation to the Road Traffic Act, if somebody has essentially been caught drink driving. Section 5, who had the burden of showing there was no likelihood that the driving of the vehicle while over the limit the reading from the top of the head note, let me just get this right. The defendant in the appeal was charged before the justices with being in charge of a motor vehicle after having consumed so much alcohol, the proportion of it in his breath exceeding the prescribed limit. He argued the defence under section 52, which cast upon the defendant the burden of proving that there was no likelihood of his driving the vehicle while over the limit. So that was the defence there. And then at the end of the first page of the head note, in relation to a charge of belonging to a organisation under the Terrorism Act. We see there the reverse burden related to the defence he raised, going over the page, was that the organisation had not been prescribed at the time when he became a member or professed to be a member of it, and that he'd taken no part in the activities of the organisation at any time while it was prescribed. So those were the two reverse burdens in issue. We then see that what I suggest is probably the key paragraph 21 at page 292. And it reads as follows: from this body of authority, certain principles may be derived. The overriding concern is that a trial should be fair, and the presumption of innocence is a fundamental right directed to that end. The Convention does not outlaw presumptions of fact or law, but requires that these should be kept within reasonable limits and should not be arbitrary. It is open to states to define the constituent elements of a criminal offence, excluding the requirement of mens rea. But the substance and effect of any presumption adverse to a defendant must be examined and must be reasonable. Relevant to any judgment on reasonableness or proportionality will be the opportunity given to the defendant to rebut the presumption. I pause there, or we say that is given in the suggestion we advance as to how the system should work. Maintenance of the rights of the defence. I pause there. This will be my fifth point about the number of safeguards that the taxpayer still has. Flexibility in the application of the presumption. Pausing there, I say we can evidence that in this case by HMRC still holding the burden with respect to the culpability elements. Retention by the court of a power to assess the evidence. This is my fifth point, but that's what would happen. A tribunal would assess the matter. The importance of what is at stake. This will be my third point in about the amount of tax revenue. And finally, the difficulty which a prosecutor may face in the absence of a presumption. And that's the point I wish to highlight under my second argument here, and I'll come on to into a minute. It then goes on to say security concerns do not absolve member states of their duty of basic fairness. And then the passage that we saw in Eurowines, the justifiability of any infringement of the presumption of innocence cannot be resolved by any rule of thumb, but on examination of all the facts and circumstances of the particular provision as applied in the particular case. And just before I leave this page, it might be helpful, there's a helpful and succinct summary in the paragraph above of the Janovich case in relation to the reasonableness and proportionality of paragraph 20. So if I just read that whilst on this page. The decision of the court in Janovich versus Sweden rejected a complaint that the imposition of tax surcharges was incompatible with Article 6.2 because an almost insurmountable burden of proof was imposed on a taxpayer. The opportunity was taken to restate established principles. there was no need for the Swedish authorities to prove intent or negligence, but states might, in principle and under certain conditions, penalise a simple or objective fact as such, irrespective of whether it resulted from criminal intent or negligence. There was, on the facts, an effective presumption against the taxpayer, and as decided in Salabuku, in employing presumptions in criminal law, the contracting states are required to strike a balance between the importance of what is at stake and the rights of the defence. In other words, the means employed have to be reasonably proportionate to the legitimate aim sought to be achieved. The court acknowledged at paragraph 102 that it was difficult for the taxpayer to rebut the presumption in question, but he was not without means of defence, and the court had regard to the financial interests of the state in tax matters and its dependence on the provision of correct and complete information by taxpayers, in concluding at paragraph 104 that the presumption was confined within reasonable limits.
Possibly of some interest that there seems to have been some confusion between evidential and legal burdens of proof in that case as well, because the revenue apparently conceded that section 11(2), somewhere, I read this somewhere, imposed an evidential burden, but that was held to be wrong. It's actually decided to be a legal burden.
Yes. As was discussed yesterday, my submissions are that this is what I'm asking, what I'm making submissions about is a legal burden.
Yes, I mean, it's a fertile subject or area for getting muddled up.
Yes.
Perhaps really this is another illustration of it.
Can I then just, parking the House of Lords comments and Sheldrake to one side, just seek to just emphasise this point about how difficult the burden being on HMRC could make matters. In particular, we say the facts of this case evidence it, because it would be more pronounced in cases, say, such as ours, where a taxpayer could mount an appeal of a matter peculiarly within their knowledge, such as saying the alcohol was sold on the continent, and then say it's for HMRC to prove the opposite, and we're in reality in no position to do so. And in reality, that's exactly what happened in this case. And if I could take you to my learned friend's closing submissions, which can be found in the supplementary bundle tab 6 at page 127. So this was the taxpayers' closing submissions on the key issue there, because we see at the bottom of page 127 the evidence relating to the location of global supplies, and it's paragraphs 9.2 to 9.4 that I'm going to read out. Now, I accept that essentially the taxpayers' case, at their first defence, as it were, or first point was Mr Malde is not in control, and so we can't comment. But behind that, the legal team were mounting a argument that the burden being on HMRC, the goods could have been.
Mr. Hayes, I'm sorry to interrupt you. I think I'm in the wrong place. Where are we again?
Supplementary bundle,
Sorry.
tab 6, page 127. And so it's paragraph 9.2 at the bottom of that page. There is no doubt that global acquired alcohol goods in the EU. Pause there. There was significant evidence of them holding millions of pounds worth of alcohol in the EU. Although there are question marks in relation to how many of the records relied upon by the respondents, that much seems clear. The amount of alcohol acquired requires scrutiny, but the central issue to be determined is what happened to that alcohol. Was it sold by Global in the EU, or was it smuggled into the UK by Global and sold thereafter? Of course, on that question depends whether there's liability for UK VAT and UK excise duty. 9.3, perhaps the clearest evidence of the destination of the alcohol supplied by Global are the payments received from its customers, putting to one side the funds received from Adrena, which are alleged to relate to cover loads and which supplies are accepted to have happened in the EU. Global receives substantial sums from the following UK incorporated companies, and then it lists them. Now, just pausing there was substantial evidence of a criminal operation called Operation Banjax in the UK, which created false paperwork and laundered money from alcohol evasion. And a number of those companies were part of that operation, that money coming back to Global. So there was that evidence. But then we come to 9.4. It is the respondent's case that those payments represent the flow of funds to Global in relation to the alcohol it had supplied, which had eventually been slaughtered in the UK. The appellants do not challenge that suggestion. Full stop. We say that is crucial. I'll come back to it in a minute, which seems likely from the evidence before the tribunal. However, the crucial issue is the location of the supplies of alcohol for which the payment was made. So in other words, what they were saying is, yes, Sintra Global were getting all this money for alcohol that was diverted into the UK, but did they make the sale on the continent or did they make the sale in the UK? So they accept they were getting the money for it. But this was a matter peculiarly within their own knowledge.
That may be so, but it's not rare in the criminal law generally for the prosecution to have to disprove something, which may be said to be peculiarly within the knowledge of the defendant.
Yes.
So alibi.
Yes.
If you raise alibi as a defence, you don't have to prove it. The prosecution have to disprove it.
And my response then would be to revert back to the principles that we're dealing with matter not in the hardcore of criminal law.
I see.
And we are dealing with them with the other interests about protecting the revenue of the state and those other arguments. So I have to accept that position, but we are, as was made clear in Gisela at paragraph 43, in a slightly different category, and that is my response. Yes.
Is it a relevant consideration in this context or other sort of similar contexts to bear in mind that, I mean, these civil penalties, you say they're not part of the core criminal law. It's an aspect of it that in many cases they will in practical terms offer the state the only reasonable prospect of actually getting the money from anybody.
Yes.
Because the underlying company which traded will probably be in liquidation and have no funds anyway.
Yes.
And the penalty, the quantum of the penalty is determined according to the value of the, sorry, I may have got this wrong, but it's determined in a way which reflects the primary liability which lay upon the company or trader in question.
Yes.
So from one point of view, it can be seen just as a way of giving the revenue one more arrow in their quiver for recovering money which is undoubtedly in principle due.
Yes.
Without any necessary penal connotations, other than just ensuring that the taxpayer pays what it should.
Yes. Yes. And indeed, my third point, which I'll come on to in a minute, is to talk about the financial. Yes. And I suppose slightly building on that point, and this was a point made in Eurowines, to put it as extreme, this trader was trading in shark-infested waters in an area where there was a lot of fraud going on. And so traders in that area, and this is the point similarly made in Eurowine, know that there are, the state is losing a lot of money and that they need to retain records, and there are extra expectations upon that when you're clearly trading in an area where fraud is prevalent. And the final point I wish to make in relation to the this point as to who holds the evidence and the unworkability is to go back to the case of Eurowines at volume 2, tab 29, page 510. and it is here the Court of Appeal is quoting approvingly from the Upper Tribunal decision. It's the indented paragraph 40, so paragraph 27, indented paragraph 40. And the point I seek to make is this, before reading the passage, is if the reverse burden is justified in cases such as Janovic or Eurowines, which I'll come on to in the paragraph, in circumstances where the taxpayer is faced with practical difficulties in discharging the burden, it's arguably justified a fortiori in this case, where the taxpayer is better placed than HMRC to obtain the relevant evidence. So the point there at indented paragraph 40, although we accept, as submitted by Mr Bedman, the difficulty of a trader in the chain of transactions in seeking to ascertain whether duty has been paid in all cases, such difficulty is not, according to Janovic, necessarily decisive of the question of incompatibility with Article 6.2. That difficulty has to be considered in the context of the scheme of the penalty provisions as a whole. My third point on reasonableness and proportionality is the legitimate aim of the state to collect tax and have an effective deterrent. And that principle can most clearly be set out in Janovic, the Grand Chamber, at volume 2, tab 30, page 551. Paragraph 103.
Sorry, paragraph
103. The court also has regard to the financial interests of the state in tax matters, taxes being the state's main source of income. A system of taxation principally based on information supplied by the taxpayer would not function properly without some form of sanction against the provision of incorrect or incomplete information, and the large numbers of tax returns that are processed annually, coupled with the interest in ensuing a foreseeable and uniform application of such sanctions, undoubtedly require that they be imposed according to standardised rules. And then if I just read the first half of paragraph 104. In view of what has been stated above, in particular the fact that the relevant rules on tax charges provide certain means of defence based on subjective elements, and that an efficient system of taxation is important to the state's financial interests, the court considers that the presumption applied by the Swedish law with regard to surcharges are confined within reasonable limits.
So the end result in that case was no breach of Article 6 in relation to
Presumption of innocence.
presumption of innocence, although there were other breaches which did give rise to an award in the taxpayer's favour.
Point 4, as to why it's reasonably proportionate, is consistency. I've already made submissions on this throughout, but just to reiterate, as has been made clear in both Salmon and Omar Minerals, where the burden of proof lies, the application of Article 6, and whether or not there is a justifiable infringement of the presumption of innocence, should not depend fortuitously on whether the underlying tax liability is determined separately, concurrently, or within a penalty alone scenario. It's entirely arbitrary for those factors to hang or fall just on the hap chance of the type of procedure.
I can understand why you make that submission as a matter of principle, but is there any authority that supports it?
It's quoted by the Upper Tribunal in Zaman about the point about consistency. And it's not just consistency for HMRC, it's consistency for the taxpayer themselves. Because from a taxpayer's perspective, why is it fair that some people have a preferential burden than you, depending upon the type of proceedings? My lord, it's paragraph 34 of Zaman. So at the moment, according to the Upper Tribunal's reasoning, it seems to be that Article 6 either doesn't apply or there's no infringement of the presumption of innocence in the first two scenarios, namely the separate and concurrent, but there is in the third. That seems to be the upshot of the Upper Tribunal's reasoning at the moment. And then the point I made yesterday that I needn't go through in any detail is it becomes slightly more convoluted when you've got those different scenarios being heard together at the same time, but with the same factual question underpinning it. So I just flag that I also make that point in this section, but I needn't repeat it. My fifth, I've gone quite quickly over that point. I say that is a fairly fundamental point, but because I've made it throughout, I'm not going to dwell on it now, the point of consistency. My fifth point is in relation to the numerous safeguards and protections a taxpayer has and how they still have a fair hearing. It may just be easier if I slavishly just quote the different points that I put in my skeleton on this point, because I've outlined a numerous different protections. So that can be found in the core bundle at tab 3, page 32, paragraph 39. It's at the bottom of that page. And so the various safeguards include the taxpayer will receive fair notice of the case against it in the form of HMRC statement of case and evidence. Both parties will often be legally represented. The taxpayer has the right to present its evidence and to have HMRC witnesses cross-examined. So that goes back to one of the points made in Sheldrake. Both parties are entitled to make submissions to the FTT and the law and the evidence. As per the case of Eurowines, and I'll briefly go there in a minute, it is highly significant that the taxpayer has the opportunity to discharge the burden. And I'll just keep on this page and I'll briefly go to Eurowines. The taxpayer's case will be heard before an independent tribunal. The FTT will give a carefully considered decision, having had the opportunity to assess the evidence. That dovetails with one of the points in Sheldrake as well. The tribunal rules governing the FTT procedure require the FTT to act fairly in accordance with the overriding objective, and the penalties are subject to reasonable mitigations.
And I suppose it might be said insofar as HMRC have documents, they can be obtained through disclosure.
Yes.
Do they have a duty of candour, so that even without waiting for
The
application, you have to disclose?
Lord, the basic rule, to try and summarise it fairly in the FTT, comes from two Court of Appeal decisions. The general rule of thumb is as follows: when the FTT is acting in its appellate capacity of looking at a case de novo, from a case called E-Buyer and Citibank, Lord Justice Voss placed reliance upon Rule 29 of the FTT disclosure rules, which says HMRC must disclose what they rely upon, and then if necessary, a party can make a specific disclosure request. except for a case where HMRC specifically pleads dishonesty, when it has a CPR style disclosure. In the second category of cases when the FTT is acting in its supervisory capacity, e.g. reviewing the decision of HMRC, a Court of Appeal case handed down by Lady Justice Rose in the case of Smart Price gave the indication of a wider CPR style test of disclosure. Because in that scenario, the thought process, if I can summarise the dividing line, in when you're assessing the reasonableness of the officer's decision, in that sense, the officer will know what information they considered, and hence there would need to be a greater need for disclosure. In your standard appellate case, it's often the taxpayer that's in possession of the evidence. So that's the rough rule of thumb as to the two Court of Appeal cases as to the structure.
Thank you for that. Can I ask you, in this context of safeguards for the taxpayer, can I take it that it's common ground that so far as the standard of proof is concerned, where the burden does lie on the taxpayer, the standard of proof is a balance of probabilities? Yeah.
Yes.
And it might be said that sure you characterise that as safeguard, but at least it's not the standard that the state usually bears when it has in criminal proceedings, when it has to prove that beyond reasonable doubt.
I'm turning it around, of course, in the bits that you accept that you have to prove where there's culpability, you prove to the civil standard as well.
Oh, right. So in the tax context, unlike ordinary criminal proceedings, the standard of proof is the balance of probabilities.
Yes, and it's the case that the Kawaja and I think Han are both in the authority.
Yes, I remember.
Which go to that point.
And there you take into account inherent improbability, but it's still the civil standard.
That's interesting. So that's been held to be compatible with Article 6, I think,
Yes.
for the state to bring what are, in the autonomous convention language, criminal proceedings against the individual, and yet not to have to prove its case beyond reasonable doubt.
Yes, it goes back. One Han carefully looked at the Keith report, which gave rise to the the imposition of the penalty regime, and assessed that in the mix,
I see.
and gives quite a detailed analysis.
Is it worth looking briefly at Han?
And my learned friend may be going to it. I haven't tabbed up any pages specifically to take.
So this probably is not a.
No, I can't. I can't with any concision take to right at this moment. But I, if need be, I can certainly, for my reply, draw out the necessary.
It is in the bundle somewhere.
It is in the bundle. Yes.
Yes.
So can I then just briefly just take out just highlight that what probably both Sheldrake regarded as important and Euro regarded as highly significant, the fact that the taxpayer has the opportunity to discharge the burden, that can be seen in volume 2, tab 29, page 512. And it's paragraph 38. And it's simply just to emphasise the point. Lord Justice Richards is here is saying it's highly significant that the trader can, first, paragraph 38, seek to rebut the presumption that duty was not paid, dealing with the reverse burden in that case. And just before I close my submissions with respect to this fifth point, of course, if Article 6 does apply to the entirety of the proceedings, it will, including the underlying question of liability, it will not be because Article 6 inherently attaches to tax liability, because we know from Ferranzi that's the case. It will be because separation is not possible. And therefore, the burden remaining on the taxpayer with respect to the tax liability doesn't level down the Article 6 protections to the penalty aspect. It's merely not levelling up the tax liability to a state that to a level that Franzi says it wouldn't otherwise be. So I make that point. I now seek to go through what is left, essentially the cases relied upon by my learned friend. There are 4, and by the Upper Tribunal. There are 4 in principle. I've already addressed King versus Walden and the case of Khan. King versus Walden, we say, is actually, once it's properly analysed, Section 101 is consistent with our position. Case of Khan, I've made submissions how that is consistent with our mission. That leaves 2 other Court of Appeal cases, PML accounting and Eurowines. I'm going to go through those both in turn. My overarching submission, perhaps save for 1 paragraph in Eurowines that I'll come on to, is to say that none of these cases are on point to the particular issues in this case, namely whether it's possible to separate out those parts of the proceedings which determine the criminal charge from those that don't, and who bears the burden of proof with respect to the tax liability component of Schedule 24 and 41 penalties. So they can all, in that sense, be distinguished apart from paragraph 7 of Eurowines that I'll come on to in a moment. Can I then go to PML accounting? This was a Court of Appeal case and can be found in the Volume 3, tab 35, page 671. And we see from the head note at around F, this was a case where the first tier tribunal who were charged with considering a penalty made a finding that the underlying information notice was invalid. And the majority of the Court of Appeal we see on the following page, 672, just above E, came to the conclusion that the FTT had erred as a tribunal sees an appeal against a penalty for failing to comply with an information notice had no jurisdiction to consider the validity of the underlying information notice. Now, it's in that context and with some trepidation that I come to make submissions as to my Lord's remarks in the dissenting passage.
They were on any view obiter.
The passage my learned friends rely upon can be seen at paragraph 698. And here, my Lord, Lord Justice Henderson, you are referring to the provisions in relation to the penalty. It said this: by contrast, an appeal under paragraph 47 against the imposition or amount of a penalty comes at a much later stage and engages different considerations because the proceedings are of a penal character and involve the exaction of money by the state from the taxpayer. For those reasons, it is well established and common ground that the burden of proof in penalty proceedings lies on HMRC, not the taxpayer. And it's those remarks that my learned friend prays in aid of. Now, I stand to obviously be corrected by this court, but how those remarks can be interpreted, we respectfully submit, is that was reference only to the penalty-only aspects, not to the underlying liability. And I say that for two reasons. One, because if we go back up to paragraph 98, when dealing with the underlying liability notice, it's very clear at the bottom of 98, 3 lines up, on an appeal, the burden lies upon the taxpayer in the usual way to establish the grounds. And secondly, and perhaps much more clearly, we say at 699, page 699, paragraph 104, there is cited approvingly the FTT's passage, which said this is an appeal by PLM against penalties, and the onus of proof is on HMRC to demonstrate that the penalties have been assessed in accordance with the law. If PML can show that the information to which the penalties relate was not valid, it follows that the penalties are also invalid and the appeal must proceed. Well, that is seemingly reference to an understanding that in relation to the question of liability, the burden is on PML. If they can show that the information notice to which the penalties relate was not valid, but that similar to our position in this case, the overall burden in relation to specific penalty aspects was on HMRC. So if that is the correct interpretation, then actually again we say that is actually not contrary to our case, but is consistent with our position as we submit for this regime.
I think you're certainly entitled to say that the learned judge was less clear than he might have been.
Well, but I mean,
The matter, which was not part of the argument as far as I recall at all. What did strike me as extraordinary, and still does, is the rejection by the majority of the proposition that you can't, by way of defence to the penalty, seek to challenge the underlying notice.
well, and support maybe got from Kishore for that on the Johnson versus Gorwood analysis.
Yes.
To support that proposition, but
Well, didn't commend itself to my colleagues in that case.
the second case that is Eurowind. I have to accept paragraph 7 does provide me with a wrinkle in my overarching submissions. So this case can be found at volume 2, tab 29, and the head note is at page 503. I'll read from the first paragraph of the head note to set out the facts. The revenue imposed a penalty under paragraph 4.1 of Schedule 41 to the Finance Act, that is similar to the excise penalty we have here, on a wholesale trader in alcoholic drinks on the ground that he had acquired possession of the goods on which a payment of excise duty was outstanding. The trader appealed to the first tier tribunal pursuant to paragraph 17.1 of Schedule 41 on the grounds that the duty had been paid by section 154.2 of what's known as SEMA, the Customs and Excise Management Act 1979, which apply to any proceedings relating to customs and excise brought by or against the revenue. The burden of proving that duty had been paid lay upon the trader as the other party. The tribunal dismissed the trader's appeal, rejecting its submission that the burden of proof in section 154 was incompatible with the right to a fair trial guaranteed under Article 6 of ECHR, principally on the ground that the appeals against the penalties imposed under paragraph 4.1 were not criminal proceedings for the purpose of the presumption of innocence. The Upper Tribunal dismissed the trader's appeal, holding that although the appeals were criminal proceedings, the purpose of Article 6, the reverse burden of proof was nevertheless still compatible. By way of background, and I looked this up this morning, the background to this case is that there was initially an assessment, underlying excise assessment, raised against the taxpayer. That was then withdrawn, and that assessment was for a much smaller amount, or something like 370,000. That underlying assessment was then withdrawn, and then at a later stage, the excise penalty notice, the subject of this case, was then issued in the term of, I think, millions of pounds. So there was initially an excise assessment of a much smaller amount, that was withdrawn. It was then this penalty for a much larger amount, but no coterminous assessment proceeding its way to final hearing, or indeed one that had even been made. So then if we can just go to the start of Lord Justice Richard's decision on page 505. The court sets out the background, what the issue is in paragraph 1. Paragraph 2, it recites section 41, paragraph 4, which we went to yesterday. It talks about the paragraph 3, it talks about the percentage amount depending on the probability areas. At 4, it quotes SEMA. And then paragraph 7 is what my learned friend relies upon. The effect of section 1542 on proceedings concerning a penalty under paragraph 4.1 is that the burden of proof is in part reversed. The burden is on the commissioners to establish the person in question had acquired possession of the goods or been concerned in their carriage, that the goods are chargeable with duty, and that the excise duty point for the goods has passed. The burden is on the appellant to establish that the duty has in fact been paid. So that clearly, contrary to my submissions here, is saying that the burden with respect to underlying liability aspects is on HMRC. My submission in respect of that paragraph is that it's not binding on this court, because we say it is obiter and per incurium. We say it is obiter because the issue in that case was clearly dealing with where the burden fell in relation to the SEMA provision, not the underlying liability, and there was clearly no submissions on that question of underlying liability. And it was per incurium because it did not consider the earlier Court of Appeal case of Khan, which made clear as to where the burden should fall in penalty proceedings. And I also just highlight what would be a significant inconsistency and arbitrariness if that were to be the correct provision, because, and the provision I'm going to take you to is because of underlying excise assessments, by virtue of statute, the burden is on the taxpayer in relation to them. And I'll briefly take you to that provision. So in other words, you have a complete perversity whereby if there were concurrent proceedings whereby there was an assessment followed by a penalty, by virtue of statute, the burden would be on the taxpayer to establish the underlying liability. But where it was in this scenario, where it was just penalty alone, if this paragraph 7 is correct, it would be on HMRC. And the particular provision I take you to that deals with this can be found in volume 1, tab 3, page 15. This, the passage, page 15, I'm quoting here from section 16.6 of the Finance Act 1994, which deals with excise penalty assessments, which are set out in section 12, and then the burden of proof. And section 6 says, on an appeal under this section, the burden of proof as to, and then it goes through a number of matters, shall lie on the commissioners, but it shall otherwise be for the appellant to show that the grounds on which any such appeal is brought have been established. So this is section 16 of the Finance Act that relates to section 12, which is when excise assessments are made. I should just say, by way of completeness, at 6A, the reference to sections 1A and 1B of section 8. Section 8 is the analogous section 60 in the excise sphere for dishonest evasion, but that matter has now subsequently been revoked.
So section 16 has itself been changed, has it?
Yes, it has.
Oh,
I think
yes,
what
it's
we put in
in
the
force
ver-
up to
I think what we did was,
September 2016.
yes, so I think we put in the version as was at the time.
Yes, that's it.
And I needn't take you there because it's an FTT authority, but I did include in the bundle at volume 2, tab 21, page 340, an FTT case of Tideswell, which essentially just makes the point that in normal concurrent proceedings, you've got an excise assessment burden on taxpayer, that finding passports forward through the penalty, who then just consider the bespoke liability aspects. And then the arbitrariness, if you've got that procedure, and then another one where if section 7 is correct, paragraph 7 of Eurowines is correct, the burden will be on HMRC. And I finally, on this section, just make the point that my learned friends rely upon a upper tribunal case of general transport, which can be found in volume 3, tab 44, page 958, but that is in reality a concession by counsel.
So concession by
Counsel for HMRC in that case, that the burden with respect of underlying liability for that excise provision lies on HMRC, but you can see it's relying upon Eurowines. So it was very much a concession in light of Eurowines, with no real debate or consideration. So I'm nearly at the end of my submissions with respect to ground 1. The next stage I wish to briefly go through is just go through.
Just on general transport briefly, where do I find the concession?
You find it at, so it's the authorities bundle 958. '76, I believe, in Britain. Paragraph, page 958, paragraph 76. This is counsel for HMRC, Mr Sternberg, accepted that in case of wrongdoing penalty, the legal proof lay on HMRC with respect to the requirements in paragraph 4. Of course, paragraph 4 there is the liability matters.
Yes, I see.
But we see that was very much from 77 to 78. It's very much in the context of Eurowines.
And this tribunal includes Judge Brannan, who decided Omar.
Yes.
I've forgotten. Had he decided Omar already?
I'm told, yes.
Yes, he had. Yeah.
So just to summarise that section, in reality, we say, actually, of all the cases that have been cited against HMRC by the Upper Tribunal, my learned friends, we say, on a proper analysis, King versus Walden is actually in our favour. Khan, on a proper construction, is in our favour. if our interpretation of P&L accounting is correct, it's in our favour, it's consistent with what we're saying. The only wrinkle of those four main cases quoted against us is paragraph 7 of Eurowines, which we say you're not bound by because of being obiter and per curiam. I'm now going to go, before I conclude with respect to ground 1, I'm going to go through what seem to me two of the main passages of the Upper Tribunal's reasoning with respect to this matter and just provide some comments. So we're in Core Bundle tab 6, page 109. And it's paragraph 127. We prefer not to base our decision on the extra statutory materials. In our view, we can determine this issue by reference to the principles drawn from the case law to which we have previously referred. These are penalty appeals. On all of the issues relating to the penalty, the burden should fall on HMRC, as they are all issues to which Article 6 ECHR potentially applies, unless there is some good reason to justify a departure from that principle. So pause there. We say there was no attempt at separation. We have considered whether the presumption of innocence in Article 6.2 ECHR should apply in these cases. This is not a case such as Eurowines of a statutory exception to a general rule which can be tested by reference to whether the exception is justified and proportionate response to a legitimate legislative aim. Pause there. Our submission on that is that it is too rigid an approach to say a purported infringement of Article 6 can only be deemed as justified and reasonable if it's set out in statute. And the example I give is the standard of proof in Han and that stream of cases in Kawaja, because that standard of proof wasn't set out in statute, but yet that was contested, but still it seemed to be reasonable and proportionate. In the absence of an express statutory provision to the contrary, in our view, the general rule that on penalty appeals the burden falls on HMRC should apply. Will I full stop there? We say on a proper construction of Khan, that's not the general rule. We can see no good reason to depart from the general principle in this case. These are significant penalties. They are dependent on proof of deliberate conduct on the part of Global and or Mr Malde, which even if it does not equate directly to the concept of dishonesty, carries similar connotations of moral turpitude. Well, 2 points. Firstly, that we accept that with respect to those culpability conditions, the burden would be on HMRC. So that doesn't go to where it falls with respect to the underlying question of liability. And secondly, I perhaps don't need to get into this, go down the route of this debate here, but some of the lower level FTT case law has certainly made it clear that dishonesty is very different from the culpability conditions of deliberate. And so they're not synonymous, but I don't think, in fairness to the Upper Tribunal, they're not saying they are synonymous, so it would perhaps be a slightly pointless exercise for me to litigate that point. And then the second passage I wish to go through is the bullet points in paragraph 131, which are the reasons why the Upper Tribunal didn't find it to be justified and proportionate exception. The first one, it says these penalties in this case are not of a regulatory nature. I take a very small point there in the sense that we are dealing with the same penalty that was dealt with by the Court of Appeal in Euro wines, which Lord Justice Richards did describe as regulatory. And that can be found at paragraph 34 of Euro wines. They are substantial penalties that are only payable if it has been shown there's been deliberate conduct on the part of Global and or Mr Malde that has caused a loss of tax. So that's back to that same point that we accept the burden is on us with respect of the culpability conditions. So that says nothing of where the burden should fall with respect to underlying liability. 2, the relevant issues in each case is whether Global was the owner of the goods in the UK. The issue is integral to the failure on which each of the penalties is based, and the failure to register, the failure to provide accurate return, and the failure to ensure duty was paid on excise goods that are held in the UK. Pause there. I've already made submissions in relation to that. If it was the case that if that argument holds true, then in relation to the first 2 categories of appeal, the separate and concurrent, then either Article 6 would apply, or the fact that the burden is on the taxpayer would be an unjustifiable infringement. So it's not consistent with the earlier 2 scenarios. And also, Gisela hasn't gone that far at paragraph 45 as to say that because a penalty is based on an underlying liability, that Article 6 necessarily applies to it all, or that it would be an unjustified infringement of Article 6. Those are submissions in reality I've already made. Then moving on to points 3 and 4, which in my submission in reality fall together. 3, the issue has not been the basis of a prior decision of a court or tribunal, as Sintra Global was unable to appeal following the failure of its hardship appeal, nor is a subject of an agreed settlement. And then 4, HMRC has not raised any question of issue estoppel or abuse of law. Well, we know from Kishore that issue estoppel has less part to play and it's more abuse. But in reality, the abuse point at paragraph 4 would be because of what's described at paragraph 3, which is that there had been an earlier judicial decision. My submission with respect to those 2 paragraphs is in reality that's an explanation as to why we are in a different situation in this case, but it doesn't provide a rationale as to why there is an unjustified infringement. And if it does seek to provide some rationale, it's purely arbitrary, because it's saying that, well, it just by hap chance, the way the proceedings have fallen, there has been an earlier hearing, then it's not an unjustified infringement. But if there hasn't been an earlier hearing, there would be an unjustified infringement. It's just an arbitrary rationale, we say. And then the final submission I make with respect of ground 1 is the point that the Upper Tribunal didn't place any weight on, which I'll make very brief submissions on, the extra statutory materials relied upon by my learned friends. The critical point I make in respect of that is that if in the extra statutory materials there is a reference to the burden being on HMRC, that can be seen in the context that it relates to the specific culpability condition, not the underlying question of liability. So, by way of example, in volume 4, tab 63, page 1219. And paragraph 417. One can see where the red mark is at paragraph 417. The onus of proof would rest. This is the consultation document for Schedule 41, is what we're looking at. And it's the where the vertical line is, the onus of proof would rest with HMRC on the balance probabilities to demonstrate the information provided was deliberately inaccurate or withheld by the third party. So in other words, the references have to be seen in the context of the culpability condition. And I think it's probably more clearly seen at page 1229. Paragraph 525, there would be a right of appeal to an independent tribunal against the penalty and its amount. With penalties for deliberate failure to notify, the onus would be on HMRC to demonstrate the behaviour to a high degree of probability. For other failure to notify penalties, the onus would be on the taxpayer to displace the penalty as now. The suggestion is that the grounds to displace a failure to notify penalty should be through the reasonable excuse provision specified in law, which would also form the grounds of appeal to a tribunal. The concept of reasonable excuse is described in more detail below. That in reality describes the reasonable excuse clause that we discussed yesterday. And the other point that my learned friends, I think, infer or hint at is continuation from the previous penalty regime into this new penalty regime and continuation of the burden. Well, actually, if you look at it, if you look at Khan, if you look at King versus Walden and those cases, for the reasons I've made submissions on, actually, with respect of underlying liability, the burden was on the taxpayer in relation to those previous regimes. And of course, there were other previous penalties under the previous regime, such as Section 63 of the VAT Act, which related to misdeclaration penalties, or Section 67 of the VAT Act, which related to failure to register. They didn't have any particular culpability conditions. And the position in those cases was that essentially the burden fell on they would ordinarily have been in concurrent proceedings, but the burden would have fallen on the taxpayer in relation to the underlying question of liability. And then the burden again will have fallen on the taxpayer to make out the reasonable excuse clause in those provisions. So actually, even under the previous penalty regime, we say there's large consistency with the approach that we're advocating here. And I needn't, I don't think, spend time going through all those other different penalty frameworks, but Section 63 can be found in Volume 1, Tab 8. Section 67 can be found in Volume 1, Tab 29. And the application of those penalty regimes, I've included examples of how they were applied by the relevant tribunals. The case of Butler, Volume 4, Tab 53, and the case of Sean Collins, Volume 4, Tab 57. And if one just follows there's only 2 or 3 vertical lines on each of those cases, but they clearly say that decision follows through to the penalty determination, reasonable excuse provision, burden on taxpayer. And so, to conclude, I think the only other remark I would make is that if in the cases that my learned friend refers to, if I haven't already covered them, if there is reference, say, to the burden of proof being on HMRC, my suggestion would be, is it because statute says so? Is it because it was one of the exception categories because the burden was on HMRC with respect to the underlying liability, e.g. Cattell? Or is it the case that there's a reference to the burden, but that relates to specific culpability elements, but not the question of underlying liability? And so I respectfully submit that if there are any other cases that I haven't touched upon, where there's reference to burden, they largely all or entirely fall into those categories that can be explained by our rationale. I now turn to make submissions on ground 2. Ground 2 relates to whether the Upper Tribunal were to subsume the liability to be registered appeal, which HMRC says was an underlying tax appeal within Schedule 41, with the consequence that the burden of proof also fell on HMRC. It's of note, and I don't think I need to take the court back to it, but in that permission to appeal decision, in the core bundle, tab 7, page 145, paragraph 11, the Upper Tribunal clearly draws a distinction between the burden being on HMRC in penalty alone scenarios vis-a-vis the concurrent scenario where it envisaged the burden would still be on the taxpayer. So it accepted, seemingly, that the Upper Tribunal accepted that in concurrent proceedings, with respect to the question of liability, burden was on the taxpayer. So then we say the question for this court is, was the underlying liability to be registered appeal and the linked Schedule 41 penalty and PLN, were they concurrent proceedings? If they were, even on the Upper Tribunal's rationale, and even if you're not with us on ground 1, then it follows as a matter of logic and their own acceptance with respect of concurrent proceedings that the burden of proof should have been on the taxpayer. With respect to this ground, I'm going to make 8 brief points. Point 1 is just to take you to the initial decision that there was an underlying liability to be registered appeal and decision. So the actual decision letter can be found in the core bundle, tab 11, page 307. Page 307. This is the underlying letter. I have to inform you, on the basis of available information, you are required to notify your liability to be registered for VAT no later than the 1st of April 2012, and that you were required to be registered for the period, I think it was the period. Second paragraph, because you failed to make the return of that which you're required to make in respect of the periods in accordance with the value-added tax regulations, the commissioners for HM Revenue and Customs, by virtue of the powers conferred upon them under the VAT Act section 73, assess the amount payable as just shy of 9 million. So there were 2 decisions there, one that you were liable to be registered, first paragraph, and as a consequence, paragraph 2, you owe just shy of 9 million and you're assessed for it. Point 2 is that the Central Global appealed both matters, but the appeal against the assessment component could not proceed to final hearing because they didn't make out the hardship provisions. E.g., they didn't pay the money into account. They applied to HMRC to say it would cause us hardship. That was refused. They then applied to Lady Justice Falk, as she now is, who also refused them hardship. However, the liability to be registered decision is not included within the hardship provision. So you don't. There is no requirement to show hardship with respect to that clause. These are set out in section 84 of the VAT Act. I don't think I need go there because I don't think it's in dispute, but this can be found in volume 1, tab 11, page 66. Just in case there is any doubt, I will just take you to Lady Justice Falk's hardship decision, which makes it clear that the Central Global could still appeal the liability to be registered decision. So that can be found in volume 3, tab 37, page 772. So this is the authority file. And we can see from paragraph 2 of that decision four lines down, reference to this hardship application. This does not affect either the penalty appeal or the appellant's appeal against the requirement to be VAT registered under 83 1A VATA. So there was still an extant appeal in relation to that, and we therefore say the Upper Tribunal were wrong in their permission to appeal decision when they said there wasn't. They may have been getting confused with the assessment aspect, but I'll just take you to that. So that's in the core bundle, tab 7, page 146. And so this is the permission to appeal decision by the Upper Tribunal, paragraph 14, 4 lines up from the bottom. This was so even though the practical implications of that appeal against the decision were limited, given that the appeal against the related liability was not being pursued. So it may just be that the Upper Tribunal were getting confused between the assessment component and the underlying liability, but we say they were factually wrong when they were in the permission to appeal decision here, when they were saying that the related liability appeal was not being pursued. It was.
So just so I understand, if the appeal that could proceed succeeded, what would the impact be?
The underlying liability to be registered, if that had, well, our submission is that that should have proceeded with the burden because it was concurrent.
Don't worry about concurrent at the moment. If that appeal were pursued and succeeded, what would the impact be?
The impact would then be, and I'm going to come on to it in a minute, we'd
Oh,
held the assessment in abeyance and we could have then enforced against the assessment. But we'd held the assessment in abeyance because there was an earlier question of liability to be registered.
So, sorry, if the if the company's appeal on liability to be registered succeeded,
If it had succeeded, then that would be the end of the matter.
that would be the end of it. So even though you couldn't appeal the assessment as such, if the appeal against liability to be registered succeeded, the assessment would go.
I don't think I've got a formal position. The position is we'd held the enforcement in abeyance and not enforcing against it. I mean, I'd need to take formal instructions, but yes, my understanding of the position would be we certainly wouldn't enforce against it. It may just be in the ether there, but it wouldn't have been enforced against if the underlying liability had not been successful.
Yes, I follow it. I follow that in terms of practical consequence. It would seem rather strange that, in principle, you were still owed £8 million or whatever it was.
But yes, I mean, there may just be a quirk with the way the law is in that scenario, because the assessment may notionally still be there on the books, as it were, but it would certainly, the view for why we held it in abeyance, it would certainly be deemed to be a degree of unfairness against them proceeding against it in those circumstances. I'll come on to make out this point in one moment, if I may.
Yeah.
Because my point 3 is that it is relevant to this point, and by way of background, that there's another common scenario which happens in these situations, and that, if I could just ask the court to go to volume 1, tab 10, page 62. So that's of the authorities bundle. Volume 1, tab 10, page 62. So this is the appeal provision under section 83 of the VAT Act, and about the list of the matters which a taxpayer can appeal, and they're listed under subsection 1. But if we go down to subsection P, which appears at the bottom of page 63, they can appeal an assessment under section 73 in respect of a period in which the appellant has made a return, e.g. a VAT return under this Act. But of course, what has often happened is if they haven't been registered to VAT, HMRC have issued a liability to be registered decision, they won't be in the position of normally submitting returns. So the procedure that then has been adopted by the FGT in these circumstances is set out in the decision of Pledger, David Pledger, and we can see that in the authorities bundle at volume 4, tab 47, page 1034. So at paragraph 23 here, it's probably the best summary of the procedure that I can find in the case law. In relation to the VAT assessment, it was accepted by Mr Shea that the validity or otherwise of the assessment would depend on the outcome of the appeal as the appellant's liability to be registered. And if the appellant was found to be required to be registered, then he would need to submit VAT returns for the periods in order to displace the assessment that had already been raised. In those circumstances, he was content to agree that his strikeout application in relation to the assessments themselves could be left in abeyance for the time being, along with the whole matter of hardship. The tribunal notes, however, that because the appellant has submitted no return for the period covered by these assessments, He has no right to appeal against them, section 83 1p. His remedy, if he loses his appeal against the compulsory VAT registration, is to submit returns for the relevant period, whereupon HMRC's practice is to withdraw the original assessments and either accept the returns as filed or issue new assessments which would be appealable in respect of any shortfall they consider to arise from the returns as filed. So that's the procedure in that scenario. And then just going a bit further down that page to page 1041. And right at the bottom of the page with the decision of the FTT. Subsection 4, VAT assessments. Application to strike out the appeal granted on the basis the tribunal has no jurisdiction to appeal against these assessments. However, the assessments themselves are not to be enforced until such time as the appeal in relation to the compulsory VAT registration has been disposed of. So that clearly gives, sets out the procedure. Now, what happened in this case is that we were at the door of the hardship hearing and it became clear no assessments had been raised, no VAT returns had been filed by Sintra Global. So HMRC filed a strikeout application of that appeal on the basis that it couldn't proceed because no returns had been issued. And then in a matter of days before the hardship hearing, a nil VAT return was submitted by Sintra Global. And of course, that's what gave rise to HMRC, out of abundance of caution, then issuing the alternative Schedule 24 inaccuracy penalty. But my point 4 is to take the court to the letter that we issued just before, when we were threatening, when HMRC was threatening to strike out that matter because no return had been filed. And this can be found in the supplementary bundle, tab 14 at page 231. And this is paragraph 11. So this is the letter that HMRC is serving on the taxpayer at the point that it's issuing its strikeout application. Paragraph 11. Having considered the law and the case of David C. Pledger, the correct procedure is for HMRC to apply to the tribunal to strike out the VAT assessment appeal, or the part of the appeal that relates to the assessment. If the appeal against the VAT assessment or the part of the appeal that relates to the assessment was struck out, the VAT assessment would continue to be due and payable. At this stage, HMRC would not intend to take any further steps to enforce the assessment until the appeal against the liability to be registered had been determined. Now, I accept that letter was sent in the context of the proceedings just before the VAT return was submitted, but that policy has remained the same because of the extent matter of the underlying liability to be registered. Point 5 is that Sintra Global actually does have assets to realise, as distinct from Mr Malde. And we can see that in Lady Justice Falk's hardship decision Authorities Bundle, Volume 3, tab 37. Volume 3, tab 37, page 782. So, bottom of paragraph, page 782, bottom of paragraph 38 of the hardship decision, very last sentence.
And do you believe that money is still to be frozen?
We completely have no idea. I mean, yes, I mean, there are assets out there somewhere. So. Point 6. I don't wish to frustrate the court by taking it to an FTT authority unnecessarily, but just the evidence that the usual procedure when there is a liability to be registered appeal and a penalty was the usual procedure for concurrent proceedings. I'll just take you to one example briefly if I can, which is the case of Hughes, which can be found in volume 4 at tab 54. So this is an FTT decision. At the bottom of page 1152, we can see paragraph 1 setting out this is an appeal that a trader should have been registered for VAT and a linked penalty under Schedule 41, such as ours. We then go down to paragraph 13, which is on page 1155. And we see at paragraph 13, just before the discussion heading, the obligation to notify liability to register is a relevant obligation in the meaning of paragraph 1, Schedule 41 of the Finance Act. If the taxpayer was obliged to notify liability to register and did not, then this failure to comply with the relevant obligation, which triggers the liability to a penalty. So that's just evidencing the passporting through. At paragraph 14, we see the reference that we're in a 83(1)p scenario with no assessment because a VAT return hasn't been submitted. And then fast forwarding to page 1160, paragraph 43, the tribunal rejects the taxpayer's account that they weren't liable to be registered at paragraph 43, and then essentially passports that finding straight through the underlying liability finding straight through to the penalty, and goes on to consider the bespoke culpability matters, or the bespoke penalty matters, I should say. So that, we say, is the usual procedure. And again, I needn't take you there, just give you the reference. There's another case in the bundle which shows exactly that same procedure, a case called Crandall, volume 4, tab 56. And it's that procedure we say that should have been applied in this case, and there was no reason to depart from that usual concurrent proceeding.
Not that it matters, but Carandall is again Judge Brennan, isn't it? But that's much earlier in time.
It is. I actually included that because that was actually under the old previous penalty regime under Section 67. So I gave you an example of one under Schedule 41 and one under the example of the previous penalty regime, just to make the consistency point, the 3 point. My point 7 is to go through the FTT's reasoning at paragraph 125 of the decision. So that can be found at tab 6, core bundle, page 108. So paragraph 125, which is the paragraph which deals with this point.
Sorry, I must be looking at the wrong thing.
Core bundle,
Yep.
page 108, paragraph 125 of the decision.
No,
Yeah,
sorry, the Upper Tribunal decision.
sorry.
Sorry, I'm confused. I hope you're looking at the FTC. All you're asking is
No, sorry. My point 7 is to go through the reasoning of the UT on
the
this point.
UC. Sorry.
No, I didn't make myself clear. So, paragraph 125. At this point, we should note that we have treated Global's appeal against the decision of HMRC that it was required to register for VAT as subsumed within the appeal against the registration penalty. Pausing there, we submit that's completely unheard of. I mean, unheard of. The usual procedure is that an appeal in its own right is determined in its own right and not subsumed within something else. We say there is no authority for that proposition of subsuming one appeal, one independent appeal in relation to another one in those terms. And the examples that I've just gone through set out the usual and standard procedure. Continuing, although at first sight it would appear that this is a separate appeal and not a penalty appeal, pausing there, we say it clearly was a separate appeal and that's just a matter of fact. In this case, continuing, the only practical manifestation of the decision that Global was required to be registered for VAT purposes is the registration penalty. We say that's not the case, because of course, if the liability to be registered be made out, then proceedings, they may or may not have been successful, but could have been got to try and claim that £2.7 million in relation to the assessment.
But turning it round, if the appeal by Global succeeded, then, well, at least the assessment would be held in abeyance and potentially it would go.
Yes, essentially, yes. But that, we'd say that's quite a circular point, because if it had succeeded, it succeeds in part because of where the burden of proof is.
Well, quite, but it maybe a misunderstanding, but the effect of this is that Global gets the benefit of the burden of proof being on the revenue.
Yes.
On the tribunal's view.
Yes.
The tribunal says, well, it really doesn't matter because this point is of no significance.
Yes.
But if Global would, but for the burden being on the revenue, lose, then that is a point of practical significance.
Yes. Because we could have we would have proceeded to enforce. I accept whether that money is ever reclaimable or not, we can locate it. But the point is, there was an amount there to go after in terms of the assessment of 2.7.
Yes, I see.
Could you, as a matter of legal analysis, could you have a situation where there is no penalty imposed for failure to register? And so there's a decision that you have failed to register when you were required to. The taxpayer then appeals against that decision. If we can just envisage that scenario,
yes,
in principle, on your submission, where would the burden of proof lie in that situation?
Clearly upon the taxpayer, as it would in a usual underlying liability appeal.
So your fundamental submission is that the Upper Tribunal, recognising that there was a separate appeal on the basis of it, then fell into error because it treated that appeal as being entirely subsumed within the penalty appeal.
Correct, yes. And just as a matter of principle, we would also say, we don't say that they're wrong as to say there is no practical manifestation, the only one was the appeal. But just as a matter of principle, we say it's the tail wagging the dog or the cart before the horse for how an appeal is to be heard dictated by its consequences or its practical manifestation. It should be a black letter situation that this is the appeal and this is how it should ordinarily be dealt with. It shouldn't depend upon the consequences or practical manifestation.
They also say, in this case, the only practical manifestation. On your submission, was there anything material to distinguish this case from any other such case?
We say that. Or I mean, every case would have its own factual basis, but there could you could have been in a situation. Obviously, we're in a situation here whereby the rationale was because of the hardship decision that there wasn't an assessment. It could, as we frequently see, it could be because an assessment hadn't been lodged because of the 83(1)(p) scenario. But in both, we say it should operate in the same way.
I mean, one could, but for there being a potential for you to get some money from Global, there wouldn't be a practical implication, would there?
But for that, but we say that's significant. Well, I mean, for the possibly in the scenario that I'm slightly moving outside the facts of this case, but
yes.
Say, for example, if you're just dealing with a usual taxpayer who's not then gone into liquidation, it's relevant that there's a usual a usual assessment marcation against them because that might factor into other decisions. It's not the usual processes should be followed because it could have unforeseen ramifications throughout the system. I mean,
yes, one of the purposes of procedural requirements such as registering, providing information and so on, of course, in practice is to obtain the underlying tax which is due. One understands that. But I think you would also say that that's not the only reason why the state has such rules. It's important for the proper administration of the system that people do what they're supposed to do, like registering on time and so on and so on.
And say, for an example, to take another example, say this trader or this director then wanted to go and start trading and having an alcohol, a trading approval, which they need to get from HMRC. One of the factors they take into account is compliance with other matters. So, and then you could be, say, in a situation whereby if you completely subsumed it, the taxpayer could have won on the penalty, but could have lost on the underlying liability, but won on the penalty. But that's nowhere to be recorded.
Sorry, that's
That wouldn't do it under this scenario
I
being
see.
subsumed. It wouldn't have been recorded, and then how would the officers or the tribunal, when assessing their WOGA application as to whether they should have an alcohol licence, have known that fact? They wouldn't have done. So we say it does manifest in other ways as well. It continues, the issues that are relevant in particular, whether global made taxable supplies in the UK in excess of the VAT threshold, are the same as those which form the basis of the registration penalty. Well, our submission there is, of course, that's always the case. The penalty will also be dependent upon the underlying question of liability. In our view, any decision on the imposition of the burden of proof in relation to the decision that Global was required to be registered must therefore follow the decision on the burden of proof in relation to the registration penalty. So having subsumed it, it then applies the burden of proof on HMRC, whereas otherwise it would be on the taxpayer. And then why we say this is even more peculiar is in the sense that the Upper Tribunal has already accepted in concurrent proceedings the usual position is that the burden should be on the taxpayer with relation to liability. So there's almost a carve-out being created in relation to concurrent proceedings, depending upon the practical manifestation. I mean, it's creating a subcategory which hasn't existed anywhere in the case law before, and we say is inconsistent with it. And my final point is to just make brief submissions on my learned friends' submissions in their skeleton argument. They raised a question about the order in which the FTT was asked to determine the issues, suggesting that the FTT was not invited to determine the appeals in a certain order, e.g. question of underlying liability before the penalty matters. Well, my submissions are that's incorrect, and we'll come on to a few examples in a minute. But in any event, the overarching approach, of which all these cases are, as we've seen, going through the authorities, are always dealt with, is that the tribunal deals with the question of liability before dealing with bespoke penalty matters. So it is just the norm of procedure that order flows, but actually we say that is actually what happened in this case. So HMRC doesn't make any criticism of the FTT for the order of which they dealt with the proceedings. We just criticise their finding and the UTs on the burden of proof. So the references to make out my point is in relation to the taxpayers' opening submissions. This is tab 4 of the supplementary bundle, page 77. So this is my learned friends opening before the FTT, and we see on bottom of page 76, it's going through relevant law, appeal by appeal, and then it deals with appeal 1, which is the underlying liability to be registered matter. 4.1, it says this appeal by SG challenges the respondent's allegation that SG was liable to be registered for VAT. So I make the point that here the taxpayer was seeing this as an independent appeal and approaching it in that way. And then if we scroll down to paragraph 4.8 on page 78, paragraph 4.8, the first issue in dispute in relation to this appeal is whether or not the appellant trade in the UK, i.e. made taxable supplies in the UK over the relevant threshold and was therefore liable to be registered to VAT. So my learned friend saw it as a separate appeal and saw this as the first issue. And then we did the same, HMRC did the same, so if I take you to our opening, which is in, it's the addendum to our opening, which is in tab 5 of the supplementary bundle, page 111. So page 111, paragraph 4, is HMRC going through the different appeals. Appeal 1, Sintra Global liable to be registered. Issue in dispute, liability, albeit in relation to Sintra Global and VAT only, and in particular whether Sintra Global traded over the VAT threshold. And then, as note on our, this is our opening submissions, Appeal 2, Sintra Global, this is the company Pedal Schedule 41. Issue in dispute at B, Quantum, the first appellant accepting that liability would be subsumed within Appeal 1. So e.g. you determine liability, question of liability first, and then that carries forward to Appeal number 2. And then C, Appeal 3, which is the PLN arising from that Schedule 41 penalty, issue in dispute control. The second appellant accepting liability in quantum would be subsumed within Appeals 1 and 2. So all that's then left for to decide in relation to PLN is the issue of control.
When you say the second appellant accepting something, what do you mean by that?
I was wondering that as I was reading. Was it, because this is our addendum to our opening, whether it's then following on from their opening submissions as to how they phrase the issues to be, and it's our interpretational submissions of that. But even if that's being overplayed in our submissions at that stage, I'm not sure it is, but even if it is, you've clearly got our submissions that, as to the order of which the matter should be determined, and that is a separate appeal.
But when you use the word subsumed, is that what you elsewhere describe as passporting?
Yes. It's unhelpful I've used subsume there in the context of the Upper Tribunal.
Well, I'm being very critical.
But yes, what is meant is passporting. And then we say essentially that is what the first tier tribunal did. So if we just very briefly just look at the headings of their decision making to illustrate this point, essentially the FTT looked at the place of supply issue, which was the underlying liability issue, before it looked at any of the individual penalty matters. And we can see that by going to the core bundle tab 10 at page 291. So it's core, so out of the supplementary bundle now, we're out of the core bundle. So page 291, here we have the FTT having, for the first 100 or so pages, gone through the facts. It then has a subheading above 588 saying issues. Going on to the next page, 292, subheading, it deals with burden of proof. Going on to 293,
it then deals with what's called order of issues. This is the ground 3 point as to whether control should be dealt with before or after place of supply, not this order of issues that's being debated here. And then we move on to page 294, the place of supply, which is essentially the underlying liability question. And then the tribunal goes on to decide that. So it does deal with the underlying question of liability first. It's not dealing with everything as some amorphous, rounded situation where it's dealing with all the penalty aspects at the same time as liability. It's dealing with the question of liability first. And we can see that again being made out because at page 304, and paragraph 665, because it's found against HMRC on the question of place of supply as far as Sintra Global is concerned, it says this: given our conclusions in relation to other issues in this case, it's not necessary to determine this issue. And that's a bespoke personal liability issue about whether it was in time. And it's also evidenced by the fact it doesn't go on to consider, obviously, the culpability elements with respect to Sintra Global, because it didn't need to, because it dealt with the liability to be registered first. And the final point with respect to my learned friend's submissions, essentially, it's just an extension of the point, but they say the FTT was not invited to divide the proceedings, e.g. between, say, concurrent or penalty alone. Well, no, because we were saying the burden should be uniform. It's only, we're just making submissions now in response to the UT having created that carve up. So we're making situations in response of that. So that's right, we weren't inviting the FTT to divide the proceedings because that wasn't an issue at the time. I now intend to move on to ground 3. I should make it clear that this ground is on the basis that we lose on grounds 1 and 2 and the burden is still on HMRC. We still submit we should be successful on ground 3. Ground 3 is our submission that the Upper Tribunal erred in law when it decided the FTT's error of law, which was to compartmentalise the evidence, was not material to the place of supply issue, with the consequence that it refused to set aside the FTT decision. Our submission is that the error of law is that the Upper Tribunal adopted the wrong approach when considering the matter of materiality. We suggest the higher court needs to ask itself whether the error was objectively capable of being material, rather, and this is where we say the UT fell into error, than focusing on whether it was material through the prism of the FTT's existing thought process and reasoning, which was itself tainted by virtue of having failed to consider the totality of the evidence. To outline what the issue is, if I just turn to the UT decision, tab 6, core bundle, page 110. Paragraph 136. The focus of this ground is again on the matter in which the FTT determined the place of supply issue. In summary, Mr Hayhurst says the FTT took a wrong step at 6:05 when it decided to determine the place of supply issue before deciding whether Mr Malde was the controlling mind behind both Sintra SA and Sintra Global. The effect was that the FTT decided the place of supply issue without taking into account the evidence as to whether Mr Malde controlled Global. In doing so, the FTT failed to consider the evidence as a whole before reaching its conclusion, contrary to the guidance of the Court of Appeal in CCA Distribution and Davis and Dan. And by way just of further background, paragraph 143. Whatever the merit of the argument put forward by Mr McGuinness of King's Counsel before the FTT and repeated by Mr Hayhurst before us, it is difficult to see how a finding that Mr Malde was in control of Global was not, at the very least, potentially relevant to the place of supply issue. If the FTT had considered this question and concluded that Mr Malde was in control of Global, and so ought to have been able to produce trading records for Global, this had at least the potential to damage the respondent's case on the place of supply issues. And so it's as a consequence of that that it agreed there was an error of law. But it found at paragraph 148 that it was not material. And what I seek to do now is go through that paragraph 148 and make submissions in relation to it. The UT said first, the FTT decided the place of supply issue in relation to both Global and SA on the basis which had little connection with the issue of control. So pausing there, we say that reason is entirely circular. Of course the FTT decided place of supply on a basis that had little connection with the issue of control because it explicitly said it wasn't taking control into account. So we say that is evidence of our submission that they did not look at the question standing back objectively whether it was capable of being material, but they looked at it through the prism of the FTT's flawed approach. Next line. In relation to Global, the FTT decided the place of supply issue on the basis that HMRC had failed to prove that Global was the owner of the goods supplied in the UK. So this here is relating to the burden of proof. We've seen elsewhere in the UT decision that they felt that this case hinged on the burden of proof. And it's my respectful submission that cases that hinge on the burden of proof are by their very nature borderline, or at the very least not clear cut. And in my skeleton argument, I've referred to paragraph 40 of Doorstep Dispensary. I mean, my lord, that didn't go quite as far as describe it in any way. I don't seek to make out to say it was describing as a case that falls on the burden of proof as being one that is borderline. It didn't go there, but my submission is certainly not clear cut. So I don't take it any further than that, but I make the point. But I do then rely, if you're with me or you think there is some merit in that submission, on the Court of Appeal's observations in CCA, where it made the following comment at volume 3 of the authorities bundle, tab 38. Page 794. So here on page 794, Lord Justice Richards at paragraph 23 is quoting approvingly the Upper Tribunal. And I'll come to Lord Justice Richard's passage in a moment, but indented Upper Tribunal paragraph 83, which is just below H. HMRC submitted that this irrelevant matter was considered by the judge to be highly material. While CCA accepted that the judge regarded this matter as relevant, it submitted that it had not been demonstrated that the judge regarded it as highly material. This is the Upper Tribunal's assessment. We have no way of knowing what precise weight the judge gave to this matter. He plainly gave it some weight. In a borderline case, a matter which has some weight is capable of affecting the outcome. And then the Court of Appeals decision we can see at paragraph 27 on page 795. And they agree with that analysis. Third, CCA emphasises that the FTT had the advantage of seeing and hearing Mr Trees give evidence over 4 days, and the judge's conclusion reflects a careful assessment of his credibility. It submits, on any fair reading of the decision, it is inconceivable the judge would have reached a different conclusion if he'd ignored as irrelevant the criminal investigation. With respect, this cannot possibly be so. Once it is accepted that it played some part in the judge's conclusion, it cannot be known what his conclusion would otherwise have been, all the more so in a case that he himself described as borderline. So we say, and for reasons I'll go on to further elaborate in a moment, we suggest this error clearly did play a part. The Upper Tribunal went on. The main reasons for this failure were the evidence of payments to Global by various companies for the alcohol supplied by Global. Well, we don't accept that's actually right. That wasn't one of the reasons given by the FTT. The evidence of payments was what it used to narrow down the issues, but that was not a reason against HMRC. And if I can just take you to the FTT decision in tab 10 of the core bundle, page 299. So here at paragraph 638, this is the FTT making reference to that payment evidence, and this is the context of which it makes reference to it in its final remarks. And it quotes passages from my learned friend's closing that we've already seen, but I'll just repeat. Perhaps the clearest evidence of the destination of the alcohol supplied by Global are the payments received from its customers. Putting to one side the funds received from Adrena, which are alleged to relate to cover loads and which are accepted to have occurred in the EU, Global receives substantial sums from the following UK incorporated companies. It is the respondent's case that those payments represented the flows to Global in relation to the alcohol it had supplied, which had eventually been slaughtered in the United Kingdom. The appellants do not challenge that suggestion, which seems likely from the evidence before the tribunal. However, the crucial issue is the location of the alcohol for which payment was made. And then the FTT says we accept that this is indeed the crucial issue, given that, as described above, there were undisputed payments to Global from those companies. So it's not saying that the evidence of payments is a point against HMRC. What it's saying is this is one of the factors that narrow down the issue to being place of supply. So we respectfully say the Upper Tribunal were wrong when they were saying one of the reasons finding against HMRC were these payments. That's not right. What the FTT was saying here is they was using that to narrow down the issue to place of supply. the UT then goes on to say the evidence and the other entities were involved in the supply chain that HMRC's analysis ignored. Well, I accept that the FTT did place reliance upon that, the other entities in the supply chain. But our submission is this: seeing as it was conceded by the taxpayers in that passage we've just seen that Sintra Global owned the alcohol on the continent that was eventually smuggled, Mr Malde, who was in control, would have been very capable of explaining and evidencing the role of those other companies. Did he sell it to them? Where's the evidence? And so once control is taken into account, it becomes highly relevant.
Is it right, there isn't anywhere any actual finding that Mr Malde controlled Global, although it seems an irresistible inference?
Yes, and I think it's been accepted by my learned friends that that would almost certainly follow from the finding in relation to Sintra SA. And HMRC's point would be that if you hadn't produced evidence on this point to say, well, look, you're saying the alcohol, or you're putting forward that alcohol could have been sold on the continent, that would be entirely within your knowledge and ability to provide the evidence in relation to that. And we could ask, even though the burden was still on HMRC in this scenario of ground 3, it would be open for HMRC to ask the FTT to infer that he was seeking to deny being in control purposely to avoid having to provide the evidence.
There's a certain affinity here, I think, with some of the issues that arose in awards of drinks. I can't remember quite how it played out, but it was...
And Zama, yes.
Yeah, exactly.
So the extent to which I can go for a case law to hang my hat on the wrong approach of the Upper Tribunal to the test of materiality is the case of Edgeskill in the Authorities Bundle, Volume 3, tab 39, page 847. And it's paragraph 208. This is the Upper Tribunal. If it is correct, it's necessary, here they're talking, I think, about the alleged errors. It is necessary to assess first whether the errors of fact alleged were plainly findings that the FTT, acting judicially and properly instructed, could not have made. And secondly, if unequivocally erroneous findings are demonstrated, whether it has then also been demonstrated that they infected the ultimate determination so as to render it perverse or unsafe. A negative answer to either stage negates any error of law.
Sorry, which paragraph is that?
208.
208, okay.
But the passage I take from that is whether the error infected the ultimate determination.
As a kind of shorthand, I've always rather taken it that one can boil this question down to it not being a question of whether the error would have had an effect on the ultimate determination. It's enough if it simply might have had an effect.
But then I would certainly adopt that as well.
I mean, there's a rule of thumb that normally seems to answer the question.
Yes.
Maybe it needs a bit of refinement.
But, well, and then that's also consistent with the Court of Appeals passage in CCA.
Yeah.
And this isn't, if I may respectfully say so, something unique to the tax context. In many fields of litigation and indeed in administrative decision, where a court is sitting on appeal and it concludes that there has been a failure to take account of a relevant consideration, there's been an error of law in the decision maker below. there are circumstances in which you can then go on to say, well, nevertheless, it didn't make any difference. But the general principle, as I understand it, is not to put yourself in the shoes of deciding what would the decision have been, but simply to ask whether it might have been different. If it might, then that makes it material.
Yes. And this isn't one of the cases, like I was briefly coming to it, called Area Technology, which is an upper tribunal decision when there were 36 or 40 allegations of errors of law and only one was made out. And the upper tribunal said, well, that's not material in the grand scheme of things. That's one evidential point in the grand mix. Here, this fundamentally, we say, goes to the question. And also the point I was going to come to, but I'll make now, in the two cases, Court of Appeal cases that we relied upon, the Upper Tribunal, and Davis and Dan, where there was a failure to look at the evidence holistically, but look at it in a sort of separated fashion, both findings were found to be material. I'm going to finish before lunch, but if I can test the court's patience to go through 7 factual documents in 5 minutes to make the point of the significance of the issue of control to place of supply. If I could, we're in the supplementary bundle. And it's tab 19, page 277. This is a fax release note from Sintra Global to its warehouse, the warehouse it used in Dunkirk, called Dunkirk Bonded Stores, dated the 7th of October 2013. And it says at the top, as discussed on the telephone, please could you release the following goods for delivery to the account of Isabella Hironowicz at Care Distribution, which is another warehouse. I just pause there to say that the FTT recorded in its decision how there was never any evidence of payment from Isabella to Sintra Global. But of note to the point I'm seeking to make here, if we go to the bottom of the page, we can see 2 reference numbers. The first one, although the handwriting's not, it becomes clearer on subsequent documents. It's ZS0317Y, and then another reference ending 4419. So if we keep that and the date in mind, 7th of October, we then just go forward to the next document in the next tab. This is the consignment document, the vehicle document of that load going from DBS warehouse to Care Distribution. Who are based in Cologne. We can see the date, top left, 7th of October. And we can see the 2 references that I've gone through, ZS0317Y and the one ending 4419. They both match.
Sorry, where do we see those?
Top right.
Top right, okay.
Ending 4419
Yes,
and the same reference number for the vehicle.
Yes.
Transporter being East-West Transport, which was our case at FTT, Mr Malde had some connection to. But it was also our case that the transporters often got interchanged. But we note at the bottom of that page what is known as the unique ARC number, which is the movement, all alcohol movements under bond in the continent that haven't been released for consumption require a unique reference number, ARC number, and we can see there the ARC number ending 947. So now moving on to the third document, bearing in mind that ARC number 947. The next document at 282 is when you move a load on the continent that's in duty suspense, you need to log it with the EMCS system. And that's what these pages come from, the log that was made with the pan-European system. And although you can just about see it, the top ARC number there ends in the 947 number. And so this is the log of that movement, purportedly going from Dunkirk bonded stores to care distribution. And you can see on that page 282, dispatch date and time, 7th of October 2013 at 17:25. We can then see on the following page, 283, what's the date of arrival of the goods being the 8th of October, so the following day. And we can see there they are arriving at distribution reportedly. However, going on to the next document starting at page 285, this is the automatic camera technology at Dover taking notes of vehicle registrations, and it goes from bottom up. But you can see there the bottom entry, a lorry going from Calais to Dover on the 8th of October, recorded at Dover at 01:20 on the 8th. And linked to that registration number of that lorry, ending 17Y, with a haulier who's Brunel, of which Mr Malde was director. So it would have been near on impossible for it to get to care distribution and then go to the port, have gone in the queue, loaded, got across the channel and for the AMPR to pick it up at 01:20. So our case was, it couldn't have got to care. So you seem to have a false paperwork trail there. And of note, whilst we're on this log, if we go upwards on the log, we can then see that lorry stays in England until almost just 26 hours later, and on the 9th of October then comes back at 3:20. And then shuttles back to Calais later on the 9th at 23:35. So it's shuttling backwards and forwards between the haulier on all occasions is Brunel, which is a company owned by Mr Malde. Going over onto the next page is a further internal movement log with the EMCS system, and I'll come to it in a minute. It's that very lorry that we've seen is actually in the UK, apparently going from care distribution to Italy. So I'll just make out this point. So what we've got here is another log, star date, this is page 287, date and time the 8th of October 12:35. A load going from care distribution to DAB, they're based in Italy, some 12 hours away. That was a finding by the FTT. On the 8th of October. But the lorry that's assigned to this on the movement system, if we go over onto page 288, is we can see there halfway down the page is a lorry ending 17Y.
So how is this compiled?
This is because the warehouses when alcohol is moved have to submit this data to the system.
Yes, I see. So the data is submitted by the warehouses.
Yes. So but the upshot of this is you've got a lorry that apparently went from Dunkirk bonded stores and apparently got to care distribution, but it was in the UK, and then it apparently goes 12 hours on the way to Italy. We know that lorry is shuttling backwards and across because of the number plate technology system, backwards and across to England and over. It's nowhere near Italy at that time. You've got a false paperwork trail saying this lorry goes first to care distribution and then across to Italy. But we know the lorry is in fact going backwards and forwards to the UK. And then we see there on the following page 289 that it apparently arrives into Italy, the destination, on the 9th of October. Doesn't give a time. And we can see again at 290, we're still talking, it's definitely, this is all from the same log, but again the reference to the same vehicle number ending 17Y at page 290. But at the same time this is going on, and this is page 293, so at the same time we say you've got this false paperwork trail because the lorry is actually in the UK, at the same time we say there is actually a cover loading operation, e.g. whereby paperwork has been created for a load going from France to the UK, so that if a load is stopped, they can hand over this paperwork to say this is a legitimate load. And so we see at 293, what we say is the movement entry for the cover load. And you see at 293, this load going from Adrena going to, on the 7th of October, this cover paperwork was opened up on the 7th of October 2013, and just after 3:30 in the afternoon, going from Adrena to Corktech, which is a company owned by Mr Malde. So remember that the lorry on the FTS log goes across at 1:20 on the 8th in the morning. This cover paperwork is in operation. Should it be stopped, it can present this cover paperwork to say we're a legitimate load, say HMRC. But that cover load of paperwork ceased to be effective because a load using that paperwork was intercepted, and this we then come to the big sheet here. So if we compare on page 293 in the supplementary bundle, you can see the ARC reference number ending G7QO.
Sorry, where are you?
So in the supplementary bundle,
yep.
Top of page 293, you can see the ARC number. It starts with 13 and then ends G7. You can't quite make it out, but at QO.
Sorry, oh, I see. Yes.
But this is the big A3 sheet here is a printout from the interception log of the loads that were intercepted at Dover. And you can see just before the fold on the left, you can just make out the ARC reference number, starts at 13 and ends in G7 Q0. And if we just go to the left, that load was intercepted. If you go to maybe the 7th or 8th entry in, you can see interception time 7:45, interception date maybe 4th, 5th entry in, 8th of, it's in American format, 8th of October 2013. So in other words, the point here is at the point that that first load moved across, that was apparently going to care distribution, but in fact went across the channel, at that same time, what we say cover paperwork was in operation of a load going to Mr Malde's warehouse called Cortec. So pulling the strands together, our questions, if it's established that Mr Malde is in control, to him in cross-examination, is why is a load with Sintra Global's name on it, on that first piece of paper, going across the border when no duty has been paid? If you're saying duty has been paid on that load, where's the evidence of it? If you're saying you sold it to someone else on the continent on the 7th of October, where's the evidence of that sale to someone else on the continent? And where's the money of you being paid for it? Why did you partake in creating a false paperwork trail, or why were you involved with it going to care distribution at the very least when it didn't? I accept they possibly may have had nothing to do with the Italy leg. Are you denying being in control because you've got no credible answer to these questions and you haven't got the evidence? They are all, even if the burden's on HMRC, that is incredibly powerful evidence. You've got to answer why a load in Sintra Global's name is going across the border when there's no evidence of duty having been paid on it, and there's a false paperwork trail of it going somewhere else. That has to be, on any objective analysis, highly relevant, even if the burden's on HMRC to place of supply. And so that is why we say at the end of the passage I was going through by the tribunal, which is there, paragraph 148, the last passage, it's difficult to see how the result would have been any different if the FTT decided that Mr Malde did or did not control Global before addressing the supply issue. Well, we say it clearly would have been, because the tribunal would or should very much have had all those questions very much in mind. And that's highly relevant. Those factors are highly relevant once you've established he's in control. And if he's not providing an answer to any of those questions, there is a very strong inference that the reason why he's not is because he hasn't got any evidence that in fact it had sold on the continent, and that he was moving it across the UK. And also, if you had sold it to someone else on the continent, why are they using your haulage company? Brunel. I mean, there is a whole host of questions there that we say are highly relevant to place of supply.
So just to understand, Mr Malde did give evidence.
Yes.
Presumably he was asked these questions.
Well, his case was, I'm not in control. So the vast majority of the questions were premised upon, look, you are in control of it, and we made out our case on that. I think he was cross-examined for 5, 6, 7 days. I mean, whether I would need to check the exact line of questions, but I don't think every single individual line of, because we've had 7 days of, well, I'm not in control, I can't answer it, would have been coming back at us. So it was prefaced on that first line of defence that he wasn't in control.
Yes. But you say, well, when the tribunal concluded that he was in control, they might have thought that his failure to answer questions that possibly hadn't been asked could have affected things.
Well, or that the reason why he was denying being in control is he didn't have answers to all this evidence.
Yes.
And we say that's a clear inference that Unless I can assist you any further, that brings me to a close of my submissions.
I don't detect any more questions. And Mr Webster, it seems a bit silly for you to start for 5 minutes before lunch.
Yes, I think my learned friend's 5 minutes was more like a Lake District mile, which we all know lasts rather longer than the signposts indicate. 2 o'clock or 5
Yeah.
2?
2 o'clock.
Court, rise is able.